Okay, will the defendant need to be sworn? Will he be testifying?
Yes, Your Honor, and I do have another witness that's here present with me. If you want to, I don't know if you want to swear them both at the same time or.
Okay, is that going to be your first witness?
No, my client will be the first witness, Your Honor.
Okay, so will she be able to go to a different room or go somewhere else?
Yes, ma'am. I can have her go out into the waiting room.
Okay, we're on record in cause number CR 2328766, State of Texas versus James David Head. Please state your appearance for the record.
Jessica McDonald, attorney for Mr. Head.
Shane Hazelton for the state.
All those.
Deborah Head.
A witness.
Witness.
Okay. All those intending to testify, please raise your right hand. Do you swear or affirm the testimony you'll give will be the truth and nothing but the truth?
I do.
Okay. And if Ms. Head can go to a different room?
Ms. Head, go ahead and just wait right out.
And Judge, I will have one witness who was going to be logging on here in a few minutes, but she'll be on, I believe, about a couple more minutes.
Okay. All right. Ms. McDonald?
Yes, Your Honor. By way of just a brief opening, I expect that through my witnesses today will show.
Before we jump, and let me set the stage, because this courtroom showdown is one of the most chaotic sovereign citizen meltdowns you'll ever see. Today's defendant, James Head, is not only fighting his fourth DUI arrest, but also trying to get the presiding judge kicked off the case by claiming she's personally biased against him because she once visited his wife in the hospital 14 years ago and brought a baby gift. Yes, you heard that correctly. Now this case gets even wilder because James doesn't walk into court alone. His mother, who has her own criminal history connected to the same judge, is part of this drama too.
Will show that there have been outside of the courtroom, outside of the just her interaction with him in the courtroom, that there were things like Judge Blake visiting when Mr. Head's ex-wife had a baby and things of that nature. I further expect that the testimony will show that the divorce between Mr. Head and his now ex-wife was quite contentious and ugly. And I believe the evidence will show that my next witness, Miss Deborah Head, has actually had some criminal charges filed against her that were in front of Judge Blake, arising out of incidents with Mr. Head's ex-wife, again, the person with whom Judge Blake had, you know, at least a professional relationship, and perhaps a bit more when you take into account, you know, her doing nice things like, you know, sending baby gifts or visiting out. B, rule of civil procedure 18B, that you recuse Judge Blake because she very well may have a personal bias against Mr. Head based on her interactions with him and other members of his family. And if not, then we're asking that you grant that under 18B1, that the impartiality might reasonably be questioned. We want our justice system to not even have the appearance of any impropriety. And so with all the factors we expect to show you today, we ask that you find under 18B 1 and or 2 that Judge Blake should be recused from this particular case. I'm sorry, I couldn't hear that, Judge.
You can call your first witness.
Thank you. I will call James Head. Mr. Head, please state your name for the court.
James David Head.
How old are you, Mr. Head?
46.
And how long have you lived in Fannin County?
For 30 years.
Now, you are currently under an indictment for a DWI third offense, and that is being
At this point, something important is happening that many viewers miss. The defendant is trying to build a foundation for his bias claim by stacking witnesses early. But notice how routine and calm this part is. The judge is simply making sure everyone who plans to testify is sworn in properly. And yet, sovereign citizens often interpret even basic procedure as some sort of attack on their rights. Another interesting detail: his mother is a witness. That's already a red flag, because when your key witness is someone who has a criminal history directly connected to the judge you're accusing of bias, it usually works against you, not in your favor.
Shannon.
I'm sorry?
Shannon, which her maiden name was Sutter.
Okay. Shannon Sudworth. And so Shannon, if we say Shannon, use that first name, that is your ex-wife. Is that right?
Correct.
How long were you and Shannon married?
We were married 11 years.
And what does Shannon do for a living?
She's a stenographer, court reporter.
And did she ever work for Judge Blake?
Yes, she freelanced with Blake in the past.
Okay. So, in other words, Judge Blake has a court reporter that's assigned and in her court most days. Is that right?
Correct.
Shannon did not work as that type of court reporter that was in Judge Blake's court every day. Is that right?
That's what I understand, yes.
Okay. But you said you met Judge Blake when your last child was born 14 years ago. Can you describe, where were you when you met her?
We were in the Greenville Hospital. It was probably a day or two after. Like I say, this is, by memory, 14 years ago. But I do remember her, Miss Blake, coming in and having...
The defense attorney's opening statement is something. She's clearly trying to piece together a narrative of bias. But listen closely. Everything she mentions is personal interaction between the judge and the ex-wife, not between the judge and the defendant. And none of the interaction she describes, dropping off flowers, visiting after childbirth, professional familiarity, rise anywhere near legal standards for recusal. This is where sovereign citizen logic starts creeping in. Instead of showing actual prejudice in the handling of his DUI case, they're reaching back 14 years to a friendly gesture and try and convert it into a constitutional emergency.
Visited there. Is that right?
Correct.
What year did you and Shannon divorce?
In 2017.
And can you describe, was that an amicable divorce? Was it contentious? Can you describe that?
At first, it was both sides, and then it started getting real contentious at the end.
Now, your divorce was not in front of Judge Blake, is that correct?
Correct. No, it wasn't.
It was here in Fannin County, though. Is that right?
Yes.
Did Judge Butler preside over that matter?
Judge Butler did, yes, sir.
Okay. During the divorce, would you describe that? How would you describe things between you and Shannon? Well, let me ask you this. Today, do you and Shannon maintain a civil relationship today?
No, we do not.
Do you speak to each other?
No.
Do you have any possession and custody rights to your 14-year-old daughter?
I do, but I haven't. We usually had like a week, every other weekend, and that was eliminated last February.
Okay. And did Shannon take you back to court for that?
No, ma'am.
How did that become eliminated?
She stopped coming to my house to stay every other weekend, to where my boy was staying every other week. And now with all of this, with me going to jail in February.
This is the moment where the defendant accidentally detonates his entire recusal argument. Instead of describing something one-sided or uncomfortable, He admits that Judge Blake brought a gift for both parents, not just his ex-wife. Judges, especially in small counties, frequently interact with local families, court staff, and community members. A friendly gesture 14 years ago is not proof of personal bias. If anything, it demonstrates kindness and neutrality. But sovereign citizens often misunderstand relationships within small communities. They treat any prior interaction as evidence of conspiracy or favoritism. Here, James doesn't realize he's actually proving the opposite of what he claims.
Pled guilty, said she did that. Is that right?
That's what, yes, she did.
But the king of the car, the Criminal Mischief Act, happened during the course of the divorce between you and Shannon.
Yes. Yes, it did.
I'm sorry. Okay.
It did, yes.
And that case was prosecuted in front of Judge Blake.
Yes.
Do you have reason to believe that Judge Blake has a personal bias against you?
I do.
Objection, calls for speculation, Judge.
Sustained.
Do you feel like you've been treated fairly in front of Judge Blake?
No, ma'am. I haven't.
Why not?
I'm not I mean, it happened with my mother, and now it's happened to me now. And with the way I've been out on bond, I've done everything that I was asked to do. Maybe not in a timely manner, not on my part, but on getting these devices and all this. And I mean, I feel like that she's really biased against me just because of my past with my ex-wife. I don't know if she's like taking sides or what, but it's just, I'm not getting a fair trial on this.
You were, when you were first arrested on the offense that's currently in front of you, you were, a bond was set and you made that bond and bonded out of jail. Is that right?
Yes, ma'am.
The magistrate who set your bond, did they put conditions on you of having to wear the scram device?
No, ma'am, they didn't.
When Judge Blake reviewed your bond, did she add that device?
Yes, she did.
Now, you understand that Judge Blake can amend bond conditions as she sees fit to protect the community.
Correct.
Do you understand that?
Yes.
Okay, so that in and of itself is not anything to show that she treated you unfairly. Would you agree with that?
Well, when I first got out on bond in May of 2023, I didn't have any bond conditions other than going in to.
This stretch of testimony shows the emotional core of James's frustration, but it also exposes the consequences of his own decisions. He talks about losing visitation, losing contact with his kids, and feeling pushed out of their lives. But instead of recognizing how repeated DUIs, jail time, and erratic behavior impact custody arrangements, he frames everything as something done to him. This sense of victimization is extremely common with sovereign citizens. When legal consequences match their actions, they interpret as proof of the system being biased or corrupt. The reality is simpler. Courts prioritize stability and safety for children.
And that you attend and participate in the freedom of choice drug and alcohol program. Is that right?
Yes.
And you understand that she's mandated by law to order that you have an interlock device on your vehicle. And she did that. Is that right?
Yes.
Now, did you, through me, ask this. Did you at one time inform Judge Blake that you wanted to represent yourself?
Yes, ma'am.
Do you still at this time wish she would have allowed you to represent yourself?
Yes.
Did you feel like Judge Blake allowed you to represent yourself?
No, ma'am.
Tell the court why you feel that way.
Because she just, the way I feel it is that she thinks that I can't take care of my own affairs. I'm an infant in her court.
And now I was appointed first as standby counsel. Do you understand that?
Yes.
Where you could still represent yourself, but she had me basically there's support for you. Is that right?
Correct.
Did you want that?
No, ma'am.
Okay. Do you now when I was appointed, I filed a motion at your request for the judge asking her to modify some of your bond conditions. Is that right?
Correct. Yes.
Can you tell Judge Cooks what you do for a living?
Yes, Judge. I'm a farmer full time. I work long hours, many days. I can't. I tried to get with her with on the bond conditions to help me out because I'm working.
This moment is where everything really unravels. Not only did James's mother get criminal charges in front of the same judge, but the crime was against the ex-wife, the same person they claimed the judge is biased toward. And she didn't fight the charges. She didn't deny them. She pleaded guilty. From a legal perspective, this is devastating for the defense's argument. If anything, the judge treated the mother exactly as the law required. Holding someone accountable for keying a car isn't bias. It's basic judicial responsibility. These interactions don't prove prejudice. They show the judge doing her job even when dealing with people connected to the court staff.
But she's seen other ways.
So let me ask you this, Mr. Head. The first motion to modify bond conditions, were you asking her to take into consideration that given the harvest season coming up, you were going to work extra long hours? Is that right?
Correct. Yes.
And the bond conditions that you attend NAAA 3 times a week and that you attend and work with freedom of choice, were those putting an extreme burden on your ability to take care of your responsibilities at work?
The AA meetings I was doing online, which I was doing those 3 times a week. I could do that by my telephone in late evenings. I was doing those with the freedom of choice. I got enrolled to it to get to get those classes started, and then I had to report in on August 2nd to check in for these bond conditions if I've done what I was told to do by Ms. Blake. Other than
so, just to get some background, when we filed the motion to modify bond conditions and I had a hearing, Judge Blake learned that you did not have an interlock device on your vehicle. Is that right?
That's correct.
But you indicated to her you didn't have a license and you weren't driving that vehicle. Is that right?
That's correct.
But you did indicate you were still working. And did she order that you have then the interlock device on any of the farm equipment that you were operating?
She said she was contemplating making that happen.
Right here, you can really hear how vague and unsupported James's claims are. He says he's not getting a fair trial, but he can't name a single example of something unfair actually happening. Instead, he relies on general feelings. He thinks the judge takes sides. He feels targeted. He believes his past is being held against him. But courts don't function on vibes. They function on facts. Bias requires concrete evidence. Unequal rulings, improper remarks, procedural violations. None of that exists here. What does exist is a defendant with multiple DUIs, a contentious divorce, and a mother convicted of damaging property.
Your probation, the person you report to at probation was able to confirm that and inform the judge of that. Is that right?
Yes, ma'am.
But she had also said you had to get enrolled at Freedom of Choice. Did you have an appointment to enroll at Freedom of Choice?
I did, yes.
Were you able to make that appointment?
I wasn't. It was the week before I had that court on that Friday. And so I called and had it rescheduled for that following Wednesday, the same time that I would get the interlock device put on my vehicle.
So the August 2nd court date, when Judge Blake revoked your bond, you were able to tell Judge Blake that, I'm sorry, at August 2nd, when you were asked if you'd enrolled in Freedom of Choice and you told the court you'd had to move that appointment, is that when your bond was revoked?
No, I already did. I got enrolled the Wednesday before the 2nd, before I went to court. So I was enrolled into that class at that time.
So do you feel like your bond was revoked? Well, what is your perception of why your bond was revoked?
Well, I still don't really know why my bond was revoked, because I had, she ordered the scram device to be put on me in April when I left the jail, and I wore it for 4 months and never had a violation on it at all. And she pretty much revoked my bond because of a date discrepancy of when I needed to get enrolled.
Do you have confidence that going forward for your trial on the merits, that Judge Blake will be a fair and impartial justice to oversee your case?
No, I do not.
Is there any other reason, anything else you want Judge Cooks to hear?
So looking at this entire hearing from start to finish, it's clear the defense's recusal argument was built on emotional reasoning rather than legal substance. The supposed bias amounted to a 14-year-old hospital visit and the judge properly handling charges against the defendant's mother. Meanwhile, the defendant's own testimony highlighted a history of DUIs, strained family dynamics, and personal decisions that contributed to his current situation. Nothing presented suggested prejudice, improper conduct, or any legitimate ground for recusal. Instead, the hearing demonstrated how sovereign citizen thinking can distort normal, everyday events into imagined conspiracies.